Welcome, and we appreciate your joining us for today's panel. As many of you know, the instances of attorneys to serve as standby or advisory counsel in criminal cases has grown in recent years. But unfortunately, there is not a lot of training, there's not a lot of education, there's not a lot of law out there to educate attorneys as to their roles and their responsibilities, as well as to balance, on the one hand, their ethical responsibilities with the honoring of a client's desire to be autonomous. And today we have a star-studded panel of experts who are here to tell you how to be more effective when you are appointed by the court to serve as standby or advisory counsel, and in particular, to give you some communication tips as well as strategies. We're going to start with Dr. Elizabeth Owen. Dr. Owen has a mouthful of titles. She is the director of the Forensic Evaluation Psychiatric Court Clinic in Queens, New York, and she is also the past president of the Forensic Division of New York State's Association of Psychologists. Dr. Owen has also developed a research interest and an expertise in the area of standby or advisory counsel, particularly in the context of a population of defendants who are called sovereign citizens. So, Dr. Owen, please give us the profile of the typical defendant who wants to represent him or herself at trial.
Hey, hi, and thank you, Elizabeth, for that introduction. First of all, obviously it's a right for criminal defendants to have an attorney. It's also very much their right to decide to represent themselves. So this is something that can come up a lot in different cases. I'm speaking only about criminal cases. In terms of federal cases, not that many defendants actually decide to represent themselves. Misdemeanor cases is another matter altogether. There are some states and some cities within states that actually don't have the resources to provide attorneys to everyone who's facing a misdemeanor charge who needs or wants one. I had a list of those and they've disappeared. But generally, there are three sort of categories of defendants who wish to pursue representing themselves. One is those who are unable to hire a private attorney for financial reasons and or think public defenders are not up to snuff. My first point of contact with defendants like these, if I come across them, is to sing the praises of public defenders. Because in general, I have found that these are people who are truly devoted. This is not a calling you go into unless you really believe what you're doing. Sometimes that works, sometimes it doesn't. But this also can include this group of people, defendants who are charged with relatively minor crimes or crimes where a sentence is not likely going to be part of the equation. They think, I know my case, I can handle this, I don't want it drawn out with an attorney, so they'll try to go ahead and deal with it on their own. An example of this kind of person, although it's not someone who was pro se by choice, was Clarence Earl Gideon of Gideon v. Wainwright. And this was someone who was committing nonviolent felonies charged in Florida. But at that point in time, and this is the early 60s, Florida law said you can only be given or provided an attorney if you are facing capital charges. And so he had to represent himself. After losing at trial and after appeals, this was the case that the Supreme Court finally said, okay, attorneys have to be provided whether someone can afford them or not. I think I'll just give one example per category. The next large grouping of people who tend to want to go pro se are those who struggle with personality disorders. Sometimes they think the laws do not apply to them. Anyone who says they think the laws do not apply to them, I first think, is this political? And then I second ask myself, is there a personality disorder going on here?
Which raises the issue, is this group of defendants competent to proceed?
There's some discussion whether or not having a personality disorder is enough to make one not competent to proceed. Functionally, I think, yes, if you have a severe personality disorder and those specific symptoms that you're exhibiting interfere with your ability to think rationally, to understand your charges, to weigh the legal option, then yes, I think a personality disorder can be enough. By itself, is it enough? No. You have to get more
and also to clarify, there's no such thing as a medical definition of competency, is there? It's a legal construct.
Absolutely. Competency, just like insanity, are legal terms. You will not find either one of them in the Diagnostic and Statistical Manual, which is our Bible. And so as clinicians, what our role is to look at the underlying psychological and psychiatric factors that apply to principles that are stated in the local jurisdiction definition of competency or insanity. For example, can someone perceive, recall, and relate? These are things that psychologists can actually observe, quantify to some measure, and speak about. Their memory processing, their ability to take in information, to apply it to their own case. So we will use those psychological constructs to help form our opinion. Likewise, it is the judge who decides if someone is competent. We only give our opinions because, like you said, it's a legal construct. So personality disorders, the ones, and I won't go into what a personality disorder is unless that comes up later. There are two personality disorders that tend to crop up more than the others in people who want to represent themselves. Excuse me. Those are narcissism, unsurprisingly, and paranoid personality disorder. So in brief, someone who has a narcissistic personality disorder has a grandiose sense of self-importance, an exaggerated belief in their own abilities, often relates in an arrogant manner. This is someone who might say to you, where did you get your law degree? Who did you clerk with? You think you're good enough to, they will challenge your authority. And they can be very difficult to deal with. My tip is not be defensive. I know you want to. It's human to say, I went to a very good law school, and besides, it doesn't matter because I'm a damn good lawyer anyway. Can we curse? Sorry. So they seem to think that only they can understand themselves and their particular situation, and no one else could possibly be able to understand their thought process. How do they want to approach the case? People who are paranoid, just like it sounds, think that other people are trying to exploit them, they're trying to deceive them, trying to harm them, and therefore they'll take benign remarks as having threatening meaning. And this can be both in terms of what you as assigned counsel might say, or what anyone in the courtroom might say to them. Typically, these people are not psychotic, but the shadow over everything is, I can't trust you. Now, there are some cases where people who have been in the system repeatedly might have good reason for not trusting the system. And one of the things that you would have to do as assigned counsel is to try to put aside your own preconceptions and listen to their experience. Give them space to be heard. And that sometimes will be the only way that they will end up giving you space to be heard. There are plenty of examples of why people are paranoid regarding the criminal justice system. I'm not going to go into that. Not enough time. Except to say that having choice, there was a justice that talked about the dignity of choice. And I think this is something that a lot of pro se defendants are really trying to preserve for themselves. And the Constitution gives them that right. They are the ones who are going to have to suffer the consequences. So they are the ones who should be making the decisions on their defense, on what motions to make. And some will take that to the next further step of, therefore, I should be the one representing myself. Allowing them that dignity. And if you are assigned as co-counsel, making sure to give them that dignity.
I want to interrupt you, Dr. Owen, and ask a question before we move to Dr. Woods. Your point about dignity is well taken. Probably the most famous recent example of a defendant wanting to represent himself is Dylan Roof, the gentleman charged with shooting the people in a church in South Carolina a number of years ago. He was assigned a superb criminal defense lawyer, and he did a wonderful job. But that attorney's challenge was he could see that Mr. Roof was making so many mistakes, mistakes that were putting his life in danger, if you will. What is an attorney to do in that situation when he or she wants to, on the one hand, respect dignity, but on the other hand, sees that the client is making irredeemable mistakes?
I would lay it out as plainly and simply, as honestly as you just did. If you make this choice, these things will possibly happen or will happen as a result. Now, I'm not telling you what to do, but I want you to be fully informed. Think of it in terms of informed consent for psychologists. Make sure they know the risks and benefits of both sides, all the while reminding them, this is your life, this is your decision. And after a point, you just have to step back and say, you did what you could, and not blame yourself.
All right, we appreciate your insights. Thank you. And now we are moving to Dr. George Woods. Dr. Woods is the former as well as the incoming president of the International Academy of Law and Mental Health. He teaches a course at UC Berkeley School of Law on the law and mental health. And he is also a superb forensic psychologist. Dr. Woods, every time I talk with you, I learn something. And one day, several months ago, you used a term that I had never heard before. And that term was functional diversity. Can you tell us what the term functional diversity means? And in particular, can you relate it to people who want to represent themselves at trial? You're muted. You're muted.
Thank you. Sure. And thank you very much, Elizabeth, for inviting me to speak. The term functional diversity is a term that my students taught me. I think that I teach so that I can learn rather than to actually teach, because your students teach you so much. In one of my classes where I continue to use the word disability, one of my students gently but firmly told me to really consider the term disability, particularly in the 21st century, where we, have seen people like Stephen Hawking, who's now dead, but others. And he said, would you really consider these people disabled when you think of it from a disabled, excuse my puppies, but when you think of it from a disabled point of view, you're using, you're setting up the normal body or the normal mind as the standard by which we should all be judged. And yet that's not the way life is. Life really works on a spectrum. And that spectrum is true when we talk about abilities as well. And so their preference, and I agree, is that we really should look at functional diversity and the range at which a person is able to function, those things that they are able to do, those things that they are not able to do. And certainly as a neuropsychiatrist, I have found, working in the courts, that there is a range of abilities that people have. And you have to take that range of abilities into consideration when you're talking about someone going pro se or representing themselves. I was thinking about the conversation in terms of dignity, and I think that's really, really, really true. And yet there is probably nothing less dignified than justice gone awry. And when we think about someone going into court representing themselves somewhere on that spectrum of function, we've got to take into consideration that this is an individual that's going up against an institution, not a prosecutor, not a jury, but in fact, they're going up against an institution that has been structured, that has worked the same way for many, many, many years, and has a code that is required in the same way that Professor Owen talked about competency and insanity. Those aren't psychological terms. Those aren't psychiatric terms. Those are legal terms. So when a person that doesn't understand those terms, and more importantly, doesn't understand the implication of those terms, that doesn't understand the potential impact to them, themselves, and those are just two examples. then you can really, really get into trouble. It's so important to understand that, in my opinion, that law and certainly mental health are immiscible. They're like an oil and water relationship. And there is very little in the law that makes room for mental health.
So let's try and make room here. Keep in mind, Dr. Woods, that you're speaking to a virtual audience of lawyers.
Right.
If an attorney has a client who exhibits a range of abilities, who is functionally diverse, as you say, how is that attorney to advocate for appropriate accommodations for that defendant even before the proceedings themselves begin?
Well, let's be clear that when you look at the Americans with Disability Act, its application to the courtroom is still a very new and naive process, right? If you were in England or if you were in Norway, you would find it very different. Or even if you were in the international courts, you would find it very different. They make the kinds of accommodations that one sees that may work with functional diversity. I have not found that to be true, certainly in terms of criminal law, occasionally in civil law. So
give us some examples. What type of accommodations do they have in those jurisdictions?
Well, for example, in this one particular case in The Hague, where we had someone that was cognitively impaired, and that's, to me, a significant population that both in the United States and people that have real cognitive impairments, they stretched out the time the person had to be in court. I mean, had to, in terms of, they only held court 2 hours a day. Right. Certainly the easy things are in language in terms of translators, et cetera. But those aren't real accommodations, right? What you're talking about when you're talking about someone that is going pro se, you want them to not only understand the language, which is not an accommodation, but to understand the process, which is the real accommodation. And those have not, in our adversarial system, those types of accommodations have not been really created on a consistent basis. However, going back to Dr. Owen, I think what we do have to think about are who are the people that in fact choose to become pro se. And I'd like to add another category to the three categories that she asked. When you stop and think about the fact that currently neuropsychological disease is a brain disease. There's no argument about that. And if it is a brain disease, then you want to look at issues that are brain-based that impact one's ability to function in the court. How is their working memory? How is their processing speed, meaning the speed at which they're able to keep up? How is their distractibility? Are they able to listen to what's going on in court and say and keep notes? Are they able to say to you, can you help me with this? Can you watch this person while I'm doing this? How can they help you in the court? And if they can't, if they, in these very specific neurological ways, if they can't help you in the court, it's a problem.
All right. On that note, we're going to wrap up. Thank you for the wonderful insights you gave us, Dr. Woods. We're going to be moving from our mental health experts to our attorneys now. And we'll start with Natalie Ware. Natalie began her career as a public defender in Miami, and then she moved to Harris County, Texas, where she also serves as a public defender. And in both jurisdictions, many times, she has been assigned by the court to serve as standby or advisory counsel to people who wish to proceed pro se. So, Natalie, tell us about some of the cases you've had over the years, and in particular, the challenges that you've had and how you've surmounted them.
Sure. Hey, everyone. Thanks for having me. My first experience, I would say, would be in Miami when I was serving as a misdemeanor public defender, which is pretty terrifying when you're what's considered a baby attorney in misdemeanor world. And all of a sudden the judge asks you to be a lawyer, but not really, but kind of, and try to get them on board. But if they don't want you, then that's okay, but you still need to do it. And it's like, what? That makes zero sense, right?
And Natalie, if I can interrupt, did a more experienced attorney in your office help you, hand you some articles, some cases? What did you do to prepare yourself?
Absolutely. I was lucky to be in Miami in a really great office where we have like amazing training and amazing supervisors who literally at the send of a text, like, hurry, please help. They're there. They're there and they're willing to sit with you whenever needed, especially in trial. So I was lucky that I did have the support and I did have the resources, but unfortunately, I also know that that's not always the case in many offices, or not even for just public defenders, but for appointed attorneys who don't have offices or colleagues who are out on their own and who are getting these types of cases. In Harris County, I am working as I'm in the felony division and I work part in the competency court. We have a whole court dedicated solely to competency, which sounds like a really great thing. And it is a really great court. I think the problem is that competency, as the doctors have said, is a legal definition. And unfortunately in Texas, our standard of competency, in my personal opinion, is egregiously low. Like what they consider competent is just terrifying. So I run into this situation a lot in my competency court where clients are trying to go pro se. Luckily, we have a great judge in there who oftentimes, stops it during the Feretta and says, no way, no way.
Whoa, time out.
Mm-hmm.
What is a Feretta?
So it's a case that the Supreme Court ruled on that basically says, of course, defendants have the right to represent themselves, but that a judge is to essentially have a hearing, but it feels a little bit more like a colloquy, an exchange between, in my opinion, the way it's done. Usually in courts, it seems like more of just a conversation on what the client knows about the legal system, how, if they understand how serious their case is. It honestly, in Harris County, a lot of the times it really mirrors competency in a good, well, not in a good way, but in a good bit when I've seen them done, which also is a little bit terrifying, right? Because I just said our competency standard is very low bar. The other time that I'm usually working as not necessarily advisory counsel is on witnesses a lot. We get called into the courtroom a lot at the drop of a hat to represent a witness who has usually already gone too far in a trial and incriminated themselves or something. Unfortunately, judges don't always know when to call us in before it gets a little too deep in there. So those are my experiences mostly in what I see. When I get a client who is representing themselves, it's tough, right? Because they have that right. My style of practice is I'm extremely client-centered. I want to do what my client wants to do. And I know it's very hard oftentimes, especially with my competency clients or my mentally challenged clients, that their families are, I know it hurts them to see me do it, but my belief is that it's my client's life. Now, if they're not in a place to make a decision for themselves, that's a totally different thing. And that often does happen. But you know, what I do is I try to listen, which made me happy to hear Dr. Owen say that's what she number one recommends, because that is something it's very hard, but you just have to listen. And I find that the more I listen, the more they listen to me eventually. It is not a quick process. When I have these clients, I visit them very often. Very often. I visit my clients a lot anyway, but I'm talking like 2 times a week sometimes. Just to show them like, hey, I'm here for you. And honestly, the more I show up, usually the more they tend to ask me questions that could help themselves. And that's what I'm supposed to be there for. And the more I show up, the more confidence they have in me and the more belief they have in me. And maybe they will say, hey, all right, let's do this. You should take it back over. I mean, sometimes it happens. It's not always. And, you know, really sometimes there's no rhyme or reason to it. They just hop on board eventually and let you in. But that would be my 2 biggest tips is listen and honestly, just make yourself available, because that's one of the biggest complaints.
Have you ever been in a situation, Natalie, where the relationship between you and the client has degenerated to such a point that you've asked the court to withdraw?
Oof. I have not. I've had a client ask for me to be removed, obviously, which I think probably most of the attorneys can completely relate with. I will ask my client though. This is, I guess, so yes, I guess so, because I will inquire of my client if they seem to really have a problem with me or not being able to open up or something. I will ask them, would you feel more comfortable with someone? There are often times when I have a client who does not feel comfortable with me because I'm a woman, does not feel comfortable with me for whatever reason. And I will often ask them, is there someone that you think you would feel more comfortable working with? Luckily, I'm in an office that's big. So, you know, I often have a colleague that I can make, it sounds terrible, but make a trade for, like, hey, I can take one of your clients. This client would I think he's told me he would feel more comfortable with a man. And that's okay. Like, I want him to be comfortable in this situation. I don't want him to be embarrassed. I don't want him, you know, whatever the issue is. So I guess I have in that sense, but with my client's permission and with my client's request.
Okay, one final question before we go to Jeff. You've appeared before many judges in your capacity as advisory or standby counsel. Can you talk about some experiences you've had with judges who've been particularly effective in presiding over these sorts of matters?
Yes. So, I mean, the most effective to me are, number one, my competency court judge, who just gets where it's usually stemming from and has seen so many people with the underlying issues and things that he just knows how to speak to them, how to get through to them usually. And so that's a really refreshing thing to be in that court. As for just regular judges, to be completely honest, I believe that people who have been public defenders or defense attorneys have the skill, because they've been on the other side with the clients who have these barricades or have these issues or have these beliefs or these underlying conditions and illnesses. And so they understand. So when they speak to my clients, they really humanize them. And we have a few ex-public defenders on the bench now, and it is just so amazing to see them speak to my clients and to listen to them, because I have been before so many judges who don't even give them that little bit of respect. And it makes a world of difference.
All right.
Especially in these cases.
We can all tell, Natalie, that you've made a world of difference in the lives of your clients, and we thank you for what you've done.
Thanks.
Our next attorney is Jeff Zimmerman, who is based in Arlington, Virginia. Jeff is one of this country's foremost experts on forfeiture law, but once upon a time, he was assigned by a judge in the Eastern District of Virginia to serve as standby counsel to the accused during the course of a trial. And Jeff, I've known you for many years. I have heard many of your war stories, and I think your war story about this particular client is one of your favorites. Can you tell us how you educated yourself about serving as standby counsel, and how you developed a bond of trust with this defendant?
Sure, and thank you for all those compliments. Thank you for having me. And I'd sort of like to specify a fourth or fifth category of defendant who wants to represent themselves. And I think that it's very critical to cover all of the grounds of different types of mental illnesses and spotting them and understanding where the line is. And everyone's covering that. And so I'd like to cover the defendant who is not suffering from mental illness. I'd like to cover the defendant who simply wants to represent themselves. They're far more than competent, which is a very low standard. They understand exactly what's going on. They're not trained like a lawyer, but they're completely oriented into exactly what's happening and what their role is. The big case that Elizabeth mentions was a sovereign citizen, and I had to orient myself to him. And in fact, there was a discussion.
And what is a sovereign citizen?
So a sovereign citizen, and from the legal perspective, is somebody who has a perspective, broadly speaking and oversimplifying, that there's one world government and they're sort of a part of it. And different sovereign citizens have different perspectives on this. My client, it was the Vatican. I've had experience with others where it was the Cherokee Nation. But in essence, what they go forward with that is that they're not responsible for paying taxes. In my case, it was a document fraud case. That is that my client went on television and had seminars advertising where he would sell diplomatic documents that immunized people from traffic tickets, from paying taxes. And so the government charged him with document fraud. And in fact, they asked me, are you going to seek a competency hearing? And I said, I'm not. I think beyond the low bar that my client is oriented in time and space, which really is the federal test. Basically, I'm sitting in a courtroom and I'm the defendant. My client's very sophisticated. He just has a different view of the world than you and I. So I said to the government, are you going to seek a competency exam? And the prosecutor said, we're not, because we think it's BS. We think your guy is straight up a fraudster. We think the sovereign citizen is just a bit. That's why we're prosecuting him. And so we started there. So I guess I want to say something, and Natalie sort of hinted at this, but when you are a standby counsel for a client such as this, who clearly is competent to stand trial, nobody likes you, right? Nobody wants you there. And what I mean by that is that when a judge says, the defendant says they want to represent themselves, right? So then you have this Faretta colloquy, which a sophisticated defendant like my client easily breezed through. And then the judge says, I'm going to appoint Mr. Zimmerman as your standby counsel, right? And the defendant says, okay, Your Honor, right? And as with so many hearings, there's what's said in court and there's what's really said in court, right? So what the judge is really saying is, Zimmerman, I expect you to take over this case. Standby counsel, I do not like pro se defendants. I don't want pro se defendants. I am not fond of sovereign citizens, frankly. And I expect you at this next hearing to have taken over this case, right? And when the defendant says to the judge—
But that wasn't the term, those weren't the terms of your appointment.
No, of course not. I was standby counsel, but that was the subtext. That was deep in the judge's eyes, right? And then the defendant, when he says, yes, Your Honor, is saying, I know you're sticking me with the standby counsel, even though I breezed through the Faretta colloquy, and I intend to isolate him. I don't intend to use him, right? So the judge doesn't want you there and the client doesn't want you there. So of course, what you do, which is what Elizabeth says and Professor Owen and Natalie, is it's all about trust. You've got to gain trust. So the first thing, so for the client, they have to trust that you're there to help them, right? And for many clients, and this was an appointed case, obviously, if people retain a lawyer, you're not standby counsel, they want you. They just don't trust appointed lawyers. They don't.
Sure, you're paid by the government.
Right, you're working for them. So it's sort of for all of us who do public defender work and appointed work, a lot of it is just that, establishing that trust. And with a pro se defendant, what you do is we want to file a lot of motions. Sovsits love their motions, right? And they tend to be written, they're in this flowery language that looks like a combination of the Magna Carta and someone who took high school Latin a long time ago, right? That's how they write.
And are you required to sign on those filings?
I'm actually required not to sign on them because he's pro se. I'm not allowed to sign on them because he's the defense attorney. So the first thing I do is take all the pleadings and look at them. And I mean, there's not much there. There's a lot of stuff, but there's no cognizable issues. And I draft some pleadings with legal issues that I think are important for the case. But I actually do it in sovereign citizen language. And I call him the plaintiff in error, everybody wants. And then I file with the court all of their motions and all of my motions, which I have the client sign, right? Because he's the lawyer. But if you have a really good judge, and I did, the judge can tell which is which.
And mechanical question. In federal court, generally speaking, all pleadings are required to be filed electronically. Was the pro se defendant in your case required to file electronically? And I know it was a few years ago.
Sure. So he was in custody. So I filed them all electronically. Basically, he signed it, but it was filed electronically in my account. And in fact, quick side story, I tried to fit the box it fits in, and normally the clerks, this was in the Eastern District of Virginia in Alexandria, are fastidious about, is it in the right category, right? And you get all lawyers are familiar with this. You get dinged.
All clerks are that fastidious, yes.
Right, they're like, you filed it in the wrong thing. So of course I picked the closest it got, but there's no way to get close to sovereign citizen motions. They're not in the list, right? But I didn't get any dinged at all. And then when I went by the clerk's office, this was pre-pandemic, when you walked into clerk's offices, remember? That was awesome. The head clerk, who I was familiar with, I've been practicing in the court for decades, said, when we initially got those motions, we were going to ding you, but then we realized that you would just walk them in and drop them in our lap, that you were doing us a favor by getting them into the system. And so we're just going to let you, right? And so everyone sort of has to start appreciate what you're doing. And then the judge sees those. And then, I think you just really prep the client. And there's not a lot of cases on this, but some of the leading cases talk about the defendant does everything in front of the jury, and it's okay if the lawyer does everything when the jury is out. And I got to that stage with my client. So you're handling.
So if I can interrupt you, number one, what are some of those cases other than Ferretta? And number two, can you do things, for instance, during a trial, like give your client a note?
You can pass your client. The McCaskill case is the Supreme Court case, the leading case on this division. You can pass your client a note during court. It's really up to the judge, but basically you don't have a speaking role. So you could pass the client notes whenever the client is sitting with you during the prosecutor's examinations. You can discuss things with them. I actually had a case in this case. There were a lot of documents that we wanted to introduce, and so I prepped the client for testifying. He was just going to testify in narrative form. But one of the government's witnesses who helped him form this sort of his sovereign citizen organization, as it were, he sort of turned him on the stand during cross-examination like they were buddies. And he got him to agree with a lot of stuff. And when I realized that he kind of turned one of the government's witnesses, which I would not have been able to do because these guys were friends back in the day, I started passing him up the exhibits that we had discussed. And I said, ask him what this is. Ask him what this is. And then when he asked them, I said, now say I move in exhibit 1. And we were able to get in most of the exhibits to the point that I didn't have to put this guy on. But
Great
anytime
story.
the jury was out, I was allowed to do it. And then the judge was really good. And he would go through the motions and he would basically say, I don't find any cognizable issues in these 15 motions. And then he says, I do find some interesting issues, say in the motion to suppress. You know, I'll hear from you, Mr. Defendant. And of course, that was when I wrote. And so my client said, you know, I'll just let Mr. Zimmerman, he understands these motions better. So we actually worked out this really good division. And as soon as the trial was over, unfortunately came back with a conviction. He just said, I'm going to, I'll let Mr. Zimmerman take over. But I guess, and then also as soon as the judge started to see the difference, that's where it helped. Normally sovereign citizens and other pro se defendants are very defiant with the court. You cannot tell me what to do. You cannot stick me with a lawyer. You cannot do this, you cannot do that. And so a switch just for me to say, just listen to the judge and respond to the questions and also orient the client. And I do this with most, a lot of clients where I'm not standby, where I say, you believe that defiance of the judge and the government, this open, arrogant defiance is helpful to you, or it feels good. But what you don't appreciate is the prosecutor loves it and the hang'em judge loves it because you're handing them all this ammunition to pound you with. Don't arm them. Don't arm them. Disarm them by walking into court, listening to the judge, making your case. And so, I go back to court the first time after and says, Mr. Zimmerman, I assume, by this point, you are counsel of record. And I said, I'm not, Judge. I mean, I thought that was a pretty clean Feretta and we'll go forward. But then the client starts listening to the judge and responding to the judge. And of course they do it in their own way, but once the client trusts me, they trust me when I say that your demeanor has to change because you're hurting yourself. And then once their demeanor
Jeff, we're going to have to cut you off there, okay. but many, many takeaways from this story. We appreciate your sharing. And I saw Dr. Owen nodding incessantly during your remarks. So our final panelist is Linda Mimms. And Linda is probably one of this country's foremost advocates for people with serious brain disease. And this largely came about because of the experiences of her loved one who had a serious brain disease and who got ensnared in the criminal justice system. And in particular, Linda's family member represented themselves at trial. And Linda, tell us what it was like for you to witness that.
Well, I'll tell you, Elizabeth, it was probably the most horrific experience of our lives to see our family member shuffle into the courtroom, emaciated after being in a jail cell for 150 days with no treatment in the general population, beat up upon by gang members because our family member was in a state of psychosis, which is a symptom of a serious brain disease untreated. And when our family member came in, their hair was down over their face, down their back. It was so obvious that it was just like a lamb being led to slaughter in the courtroom. And we had done everything to try to prevent this slow-moving train wreck we were witnessing with our loved one getting sicker and sicker before he intersected the intersection of the criminal justice system and our loved one's serious untreated brain disease.
And to clarify, Linda, when your family member went to trial, the court did not represent that person or appoint an attorney for that person.
That is correct. Early on, like maybe 4 months prior to the trial, the initial judge deemed our family member competent to represent themselves. Now, This was after we had sent medical history packets to every person we could send, because he didn't have a public defender. We had no one to talk to. So once he entered into the system, it was like a black hole, and we had no way to communicate with him, because the feeling in psychosis was that our family was enemies. So we couldn't talk with them, and we had no one to speak with. Therefore, when our family member came into the courtroom, he was alone, and he did not have advisory counsel. And he was unable to defend themselves, adequately. Obviously, he was decompensating. So, there we were, feeling helpless, completely helpless, unable to say anything, and feeling extremely guilty because we had not been able to get our loved one the medical help they needed, due to all the barriers in our healthcare system for people with serious brain diseases, which has been separated out from physical disease, which is really, sad, because people with physical organ dysfunction go to a doctor, and a doctor takes care of them. People that have a serious brain disease are under a different system of care called behavioral health, which is led by laws and barriers to entry into the system. So
Linda, going back to the courtroom, when this train wreck, as you called it, began to unfold, how did the judge respond? How did the other courtroom personnel respond?
Well, I'll tell you that the jury had a look on their face. It kept looking over to my husband and I with abject pity. And one of them even approached us outside of the courtroom and said, basically, "I'm so sorry," because they were stuck there watching this spectacle. Even the PERT officer, PERT is Psychiatric Emergency Response Team officer, who had been helping us try to get our loved one into care, into the hospital. He had to testify, and he waited for us out in the hallway and was visibly shaken and said, "That is a shit show in there." Now, because of this, we were incredulous that the district attorney, who also knew the background, because I did break protocol, I was told, "Oh, don't even contact the district attorney." Well, what recourse did we have? I did contact the district attorney, and I sent the medical record. And the district attorney knew how ill our family member was and did not stop the trial. And the judge also knew as well, because we found out after the trial, then this trial was for a victimless nonviolent crime. After the trial, we found out at the sentencing hearing that the judge had decided that he shouldn't have let our family member represent themselves. And so it was all backwards. Then he ordered, the psychiatric evaluation from the forensic psychiatrist, and everything was backwards. And long story short, it took over a year, and just picture this, a year of suffering in a state of psychosis where reality is gone, and it's like a kind of a half dream state. And I've read people that have suffered from it say it's the most lonely, horrible time in their lives. And then to be left in a jail cell, no treatment, 1 year, no treatment. And then when it was finally, after innumerable hearings, finally ordered that he must have medication, then about just a handful of days, a call from the jail: "I love you. I'm so sorry. I was not thinking right. I was having delusions." It was like coming out of a coma. Now, by this time, because this state of psychosis is like a slow-moving stroke, it is actually damaging a person's physical brain. And, we just have to put a stop to this in our criminal justice system. We need everybody in the system to understand what these diseases are. They are not behavioral health diseases. They are brain diseases. And I know that our system of law is very slow moving. but there's no excuse. Once they hit the court, they hit your venue, then I think it's the responsibility of everybody in the court to understand these illnesses. Maybe the judicial bench cards can be rewritten to incorporate current scientific knowledge on these illnesses. No one in that state should be allowed to represent themselves. No
All
one.
right.
It's just plain
Well-
wrong. You know, Ruth Bader Ginsburg always questioned herself, how can this law be used for good? How can law be used for good? How is it going to affect our individual citizen? You know, and I know that you guys all want the law to be good, but there are certain times when I wish we had had an advisory council, because I would have hoped that if we had an advisory council, that they would have done the right thing and stopped the trial, because no one else in that courtroom was doing the right thing. You know,
All right, Linda, we've got to end it there, but we so appreciate your reminding us that what we do has flesh and blood consequences. Sometimes what we don't do has flesh and blood consequences. Two quick remarks before we have a brief break for question and answers. First and foremost, you should know that not only did the criminal justice section sponsor this webinar, but so did the Commission on Disability Rights. And in particular, we want to thank Amy Albright, the director of the commission, for the assistance she's given. And secondly, I made a huge slip of the tongue. I called Dr. Woods a forensic psychologist. He's not a forensic psychologist. He's a forensic psychiatrist. So with that in mind, Dr. Woods, Dr. Owens, tell us the difference between these two fields and tell us how the difference might be relevant for an attorney seeking a mental health expert. Unmute yourself.
Dr. Owens?
Yes.
Go ahead, Dr. Wood.
The significant difference between a neuropsychiatrist and a neuropsychologist, as it relates to this, really has to do with in my opinion, with the ability to test. I think that it's very important in the court to be able to have as objective instruments as you possibly can to look at, as Ms. Mimms said, some of these more objective findings, some of these brain issues and brain skills, as well as looking at their ability to actually be competent. And those are within the purview of these neuropsychologists, not the neuropsychiatrists. So if I had one person that I would recommend in this instance, it would be a psychologist or a neuropsychologist that really has the ability to provide you with the kind of testing information that can be of service.
All right, thank you. Dr. Owen, anything to add?
I would agree with that, except to say that for certain brain disorders, being able to really read and understand some medical tests, as opposed to neuropsych or psychological tests, being able to really bring those findings to life, which only a medical doctor or psychiatrist can do, can often make the difference between getting through to a judge or a jury or a defendant and not. So we each have our roles to play. It really depends upon the case and the charges and whatever the underlying disease or brain disorder is.
All right. Well, unfortunately, our time is up, but the contributions of each one of you have been tremendously helpful and enlightening, and we thank you. We also, once again, want to thank the Criminal Justice Section as well as the Commission on Disability Rights for their co-sponsorship. And finally, we want to thank all of you for attending. I personally know that each one of these people is tremendously passionate about their field of expertise. And I feel confident in saying that if you reached out to any or all of them for assistance, they would be helpful. So thank you all once again.
Thank you,
Thank
Elizabeth.
you. Thank you. It was great.
Thank you, Elizabeth.
Thank you.